and ignition. There always seems to be so much happening in the world of employment law, and this year has got a number of interesting developments, the Employment Rights Bill. So I'll hand over to Nicky and Jackie to introduce themselves and talk us through it. Thank you.
Super, thank you. Thanks everyone for joining us. I think a lot of you on the call know me already because we've worked together at one point or another, but I'm Nicky Cranfield. I'm the head of employment at Ignition. So it'll be myself and Jackie Brown who are hosting the session today. So I'll let Jackie introduce herself.
Thanks, Nicky. Hi, everyone. I highly doubt anyone will have spoken to me before, but my name is Jackie Brown. I am the head of HR at Goodwille. And for those of you who don't know who we are a management consultancy who assist businesses predominantly from a Nordic angle who are looking to set up in the UK or scale in the UK. Of course, I look after the HR function.
Thanks, Jackie. So a quick kind of overview of what we're going to cover today. Firstly, as Tammy mentioned, the Employment Rights Bill proposals, which were introduced in autumn 2024. There's a whole host of proposals that are in that bill. Today, we're going to focus on the ones that are relevant for SMEs or the most relevant for SMEs. There's a couple of other key employment law updates for 2025, and I've got one slide to just recap some others that came in 2024, and then we'll have a final roundup of practical tips for staying compliant, which Jackie will be talking about as we go through each slide. And then at the end, there'll be time for questions. So if you have any questions, please do feel free to ask then. Or if you'd rather kind of follow up afterwards, very happy to take questions on email afterwards, but do feel free to ask us at the end. So if we dive straight into the Employment Rights Bill and what we know so far. So as I said, it was presented to Parliament in autumn 2024, but at the moment, everything in that bill, they're proposals only. So none of this is in force at the moment, and it's not likely to come into force until 2026. So we're in a situation at the moment where these are the proposals that the government have made, and they are saying that they're going to consult on many of them in the meantime. So if you like, we've got a high level view of what the changes will be, but we don't know all of the detail at the moment, and that will come out over time. It's a really large bill. It contains lots of different proposals. And as I've said, not all of them are relevant for SMEs. For example, there's a whole swathe of proposals around trade unions and trade union law, which we don't intend to cover today. Today, it's going to be the focus around the Employment Rights Bill will be on those proposals that are more relevant to SMEs. So unfair dismissal rights, extended employment tribunal deadlines, changes to family-friendly rights, 0 hours contracts, ending fire and rehire, and a little bit on third-party harassment, statutory sick pay, and updates that will also be needed to employees' terms and conditions. So if we start with the kind of first and arguably the biggest change that's coming in, it is going to be introducing unfair dismissal rights from day one. So as many of you may know, at the moment, there's a 2-year qualifying period for unfair dismissal rights to accrue. So meaning that during the first 2 years of employment, it's much lower risk and much lower process to dismiss employees if needed. Now, going forward, the government's proposed that unfair dismissal rights will be a day one right, meaning that from day one, you will have to have a fair reason for a termination and also follow a fair procedure in the way that you would now once somebody has already accrued that 2 years of service. There is a caveat to that, though, because they mention an initial employment period, which is going to be akin to probationary period. And what they're saying is that during that initial employment period, there'll be a lighter touch process for dismissals or a less onerous process for dismissals. What that actually looks like in practice remains to be seen, because there'll be further regulations that are brought in to explain exactly what that lighter touch process looks like. But at the moment, it seems to be that the initial employment period will be for up to 9 months. So in a way that kind of tallies with what we would have as probationary periods at the moment, because you may have a 6-month probationary period with an option to extend that for a further 3 months. So you've got your kind of 9 months there. That would be the initial employment period. And during that period, it may be that you can dismiss without doing a full process, but rather just having a meeting and then following up in writing, for example, which lots of employers would do anyway at the moment, but it's going to be enshrined in statute what you have to do. And if you don't follow that process, there will be an option for an employee to bring an unfair dismissal claim where there just wasn't that opportunity beforehand. Coupled with that, there's going to be an extension to the time limits for bringing a claim. So at the moment, most claims can be brought within 3 months of the date that the incident happened. So within 3 months of termination, or within 3 months of the last act of discrimination. But that is also going to increase to 6 months. So employees will have a longer period to be able to bring these claims. So in terms of implications, with that kind of, you've got the double whammy of more legal protection and then a longer period to bring those claims. You're looking at, there is going to be increased risk there around terminations and potentially more claims coming through. Probationary periods are going to become more and more important and will really need to be robust. And it will be important to keep an eye on what actually transpires in terms of this statutory initial employment period. Is it going to stick at 9 months? Will there be any variation to that? And what will those procedures look like in the end? There's also a slight quirk in the legislation at the moment, which means that redundancy dismissals are carved out of the lighter touch processes. So that means that once this comes into force, if you want to make a redundancy from day one, you'll be subject to the full redundancy processes, so consultation, etc. Whereas the lighter touch processes will be available for performance dismissals or conduct dismissals. So it's definitely going to be a key change when it comes into force, but as I said, not likely to happen until 2026. Lots of practical steps that people can be taking in the meantime, though, Jackie.
Yeah, no, for sure. I mean, you touched on that there, Nicky, but I guess word on the street is we are expecting there will be an increase in ordinary unfair dismissal claims, and maybe a decrease in discrimination claims. Maybe that balance will change, but certainly it's going to be a rough ride, I would think, initially. But what can we be doing now? I mean, it's sensible to review your existing probationary processes, make sure that they're robust and well documented. And that's going to be really important if you know a consultation will result in a formal probationary dismissal procedure. So again, Nicky, you touched on that as well, that there will be some sort of formal documented process, but we don't know quite exactly what that's going to look like now. But make sure that you're getting your managers into good habits right now of documenting meetings and giving clear feedback. I can say for sure with a lot of the clients that I deal with currently that maybe doesn't happen. You know, nobody likes having that difficult conversation, and they'll get to an end of a process and maybe they'll want to make another excuse rather than tell someone they're not performing. It's like, oh, maybe the message is received better if they say that their role's redundant or something like that, rather than actually saying you're just not the right company fit or whatnot. So make sure that that isn't happening and that your managers are trained and understand and document where they need to, and they are giving that clear feedback. Also look at induction processes. So make those robust as well, cover any training that's needed to allow for the best chance of success. And that also, of course, demonstrates your part as a good employer in case of any unfair dismissal claims. We know, again, that Nicky's touched on this, that there will be an increased need for monitoring and regular performance reviews during the probationary period, but don't delay on making those difficult decisions if you have got underperforming employees, because it will become riskier to make a dismissal further down the line. And then look at all of your wider company procedures as well. So not just looking at probation, not just looking at induction, but look at things like how you would normally run a performance process, as an example, if someone has passed that initial 9-month period. So do you have robust processes in place for PIPs? Do you have robust processes for disciplinaries, redundancies? And again, just training. Make sure that your managers know how to manage, basically, that they know how to look after the people in their teams. That's really going to be key moving forward, I think.
Thanks, Jackie. We'll move on now to look at the family-friendly rights that are introduced by the Employment Rights Bill, some of which perhaps have more impact than others. Looking first at flexible working rights, and this was in, there was a lot of this in the press. Oh, there's going to be the right to a 4-day working week, lots of, hyperbole around what this change would be. In reality, in the bill, the changes are fairly minimal. Already under current law, employees have the right to request changes to working flexible working requests up to twice a year, and they have to be handled in a reasonable manner. Now, when it talks about being handled in a reasonable manner, that's more about process and procedure for handling the request, and they can be refused for one or more of the 8 statutory reasons. Now, all of that stays the same in the kind of new proposals, with the additional point being that employers must provide better, clearer reasoning for refusing the request. So now an employer, or in the future when this comes into force, an employer won't be able to say, we are declining your request because it will have a detrimental impact on performance. You can't stop there. You have to go further. You have to explain why it would have a detrimental impact on performance. Now, in my experience, many employers do that already. So if they're declining a request, they will do more than just give a headline no because of performance. They will go on and explain more reasoning for that. What the Employment Rights Bill says is that will now be a mandatory thing to do. Employers have to give that reasoning. With there being kind of so much about this in the press, there is potential that it's going to increase the volume of requests, because it becomes more public knowledge that it's available for employees to make these type of requests. And also because there will be more of a focus on the reason for declining it being reasonable, as well as the process being reasonable. It will be important to make sure that the procedures are fair and you're making consistent decisions across the board. Jackie, more from you on kind of other practical bits.
Sure. So of course, on a basic level, and I'm going to sound like a broken record by the end of the session, I think, but it's really important to have updated policies, and that your managers again are trained, but this time on handling flexible working requests. But on a wider note, I would say from personal experience of dealing with the clients that Goodwille deal with, I see many businesses will take the approach when they receive a flexible working request to immediately jump to, let's try and find a way to say no. They're not very open-minded generally about looking at this. So, we are in a different world to pre-pandemic. Many businesses claim to have embraced flexible working, but, there can be an immediate jump to saying no rather than having a more open mind and trying to give it a go. So, of course, there are certain roles and industries where flexible working isn't going to work, but we've got so many different types of requests that can be made. You know, it could be anything from location to consolidated hours or other working shift patterns that might work for your business. Not saying it's mandated to say yes, but you know, maybe think about how it maybe could be something that could work. So consider trial periods. Do you have the technology in place already to help your business work more flexibly? And then also, if you do have people who are remote working, do your managers have the skill set to be able to manage those people? Do they need any training on that front to make it really effective for you? Yeah, I think that's all I have on that bit.
Thanks, Jackie. So coupled with the changes to flexible working, there's also updates around various leave entitlements, paternity leave, parental leave, and bereavement leave. So currently, for parental leave and paternity leave, there is an entitlement to that. Parental leave's unpaid and it's subject to a qualifying service period of 1 year. Paternity leave is paid at the statutory rate, which is currently around £184 a week, and is subject to a qualifying period of 26 weeks, so effectively 6 months. For both of those, the entitlements will stay the same, but there won't be any qualifying period. So the proposal is for both parental leave and paternity leave, it will be a day one right. In terms of bereavement leave, we've currently got a position where there is 2 weeks of bereavement leave available for bereaved parents. But there's no statutory right to any other kind of bereavement leave. Now, lots of employers will provide this anyway on a discretionary basis, but the Employment Rights Bill says that this will be mandatory to provide this leave. And the proposal is that it will still be 2 weeks for child loss, but 1 week for any other kind of bereavement. Perhaps not a huge change in practice for employers who are providing this anyway, but the change is there to kind of protect those employees who aren't getting those entitlements on a discretionary basis. And I suppose there might be an increase in the volume of requests, although I suppose in reality, employers are likely to have to give this leave in those circumstances. If it's not bereavement leave, then employees will maybe take sick leave as an alternative. Any other practical tips, Jackie?
I guess, first of all, I personally think it's a great move on the bereavement front. I do think that, you know, having a death in the family is good. It's a really stressful time anyway, and you know, not knowing if you can have a set amount of time off, or you may be scared or uncomfortable to ask, can maybe make that a little bit more difficult. So I do think that it's a great move to actually have this formalised approach in the first instance. But in terms of practically what you can be doing now, again, on a basic front, update your policies, but maybe think about what rates of pay that you're going to be offering as a business. So whether you are going to stick with the unpaid where applicable, whether you are going to be giving statutory rate where it's applicable, or whether you are going to be offering any enhanced payments, and how that maybe links with your other policies as well. And think how you're going to document those leave types as well. So a lot of smaller businesses, certainly that we deal with, and I expect that Ignition may be similar, you know, maybe they don't have absence trackers and that sort of thing if they are smaller businesses. So maybe do think about introducing that to have some sort of structure to document and track those leave types.
Super, thank you. And then the last point around the kind of family-friendly leave is further protection for pregnant women and new mothers. So as things currently stand, there is protection against discrimination for pregnancy-related reasons, and there's very limited other protection for new mothers. In 2024, there was an update which meant that the protection that that women who were on maternity leave had to be offered the first right of refusal in terms of alternative roles in a redundancy situation, that was extended out. So it wasn't just while they were on maternity leave, it was while they were pregnant, and it was for effectively 18 months after the baby was born or there was an adoption. So meaning that they do have some protection after they return from maternity leave as well. But that is only in relation to redundancy situations and this right of first refusal to alternative roles. The proposed changes that are put forward in the Employment Rights Bill are woolly, to say the least. So there's not a lot of detail on how they will play out in practice. But at a high level, the government clearly wants to strengthen the protections that are there. And there is a suggestion that there could be an outright ban on dismissing pregnant women or people returning from family leave for a period of time. So perhaps 6 months after their return from a family leave. So shared parental leave, adoption leave, maternity leave. And that wouldn't just be around redundancy, it would be a ban on any dismissals, save for exceptional circumstances. So again, that aligns with some laws in other European countries where they have these stronger protections for people who are returning from family leave. But the detail of what will be proposed in the UK is still to come and will be clarified in regulations that the government put into place. So there will likely be an increased risk around terminating employees who've been on family leave, but it's kind of keeping informed on that and seeing how that progresses.
I guess in terms of what you can be doing today, as Nicky's highlighted, there isn't anything set in stone to really work on to make changes today. But I just wanted to make it clear that as it stands, as the regulations are today, it isn't impossible to make a returning mother or a pregnant mom, in this example, redundant. But of course, you just need to show and demonstrate that you are following the usual fair requirements. Of course, the person would have first refusal if there was a suitable alternative role above colleagues. But if they were in a standalone position, as an example, and there's no other opportunity than to move that person on, then that would still be able to be done. We just want to make it clear that as it stands now, it's not impossible if that is a business need.
And I think, Jackie, in future, it's probably also not going to be completely impossible to do it. It's just going to be strictly monitored, and it will come down to the fairness of those dismissals and whatever's set out in the regulations. There'll be particular circumstances where it is possible, but making it the exception rather than the rule. So that's the update on the kind of family friendly side of the Employment Rights Bill. So moving on now to think more about the other updates in there, one of which is a ban, as they're calling it, on 0 hours contract. So at the moment, the position is that 0 hours contracts can be used and there's no need to specify the hours that are actually worked by those workers or employees. So it may be that the contract has very low hours or no hours in there, but actually those employees are working, almost full time in some situations. So the purpose of bringing in these reforms is to give some certainty to employees who, in terms of their financial income and also what hours and the schedule that they'll be working. And the proposed changes come in, again, very complicated, and lots of additional regulation to come to set out the full detail. But essentially, there are 3 big kind of areas of change. One, the first being that employees will have the opportunity to be offered a guaranteed hours contract. So the way that will work is if an employee is working under a 0 hours contract, for example, after 12 weeks, the employer will need to look back over that 12-week reference period to understand what the average working week is, and they will be obliged to offer an employee that contract on a guaranteed hours basis. So if it was 10 hours per week on average over the last 10 weeks, rather than being on a 0 hours contract going forward, they would have to offer that employee a 10-hour per week contract. So note though, it's an obligation to offer the employee that contract. For some, they won't want to accept, for example, students, likely it's as good for them to have the flexibility of a 0 hours contract as it is for the employer to have that. So there's no obligation on the employee to accept the guaranteed hours, but there is an obligation, or there will be an obligation on the employer to offer it. Now that causes all manner of difficulties when you think about seasonal working or term time fluctuations, and it may be that offering it for the people who accept the guaranteed hours, it does give them some stability in terms of finances, but it may also have a detrimental impact on other people in the business who perhaps don't want the guaranteed hours, because if you can't then change the hours of the people who are on the guaranteed contracts, then it may result in lower hours for others. Or kind of to an extreme example, it may mean that employers start to think about different ways of engagement rather than taking on people as employees. Along with that guaranteed hours right, there's also a right to have reasonable notice of the shifts that people will be asked to attend, and also reasonable notice if any shifts are going to be cancelled. And if shifts are cancelled on short notice, there'll be an obligation on employees to pay compensation in those situations. So there's kind of those three different bits in terms of what reasonable notice will be and what short notice will be. Again, that's all to come in the regulations that will be drafted in due course. So at the moment, there isn't a clear view on what that looks like. But certainly, given the obligation to offer these guaranteed hours contracts and look back at a reference period, it does prevent, you know, when we talked about a ban on 0 hours contract, there was lots of talk about, oh, well, you could just offer a 1 hour a week contract or a low hours a week contract. But if it has to be tied back to a reference period, that's going to stop that. And there is going to need to be a focus on what shifts people are working and how that's going to be scheduled, and making sure that there's a balance between the flexibility the business needs and also the potential costs of kind of cancelling these things.
Yeah, so I certainly think, you know, it's going to be difficult for certain companies and certain industries such as retail and hospitality that will be more greatly affected by these changes, perhaps because they, you know, they rely on a student workforce, perhaps. But as it stands, you know, what can you be doing now? Maybe look at your current contracts that you have in place, so audit your existing contracts, look at your shift patterns, particularly those involved in 0 or low guaranteed hours, and then consider whether you should be engaging those persons already on a different kind of contract to 0 hours. So they could maybe have a part-time fixed hour contract on a fixed term basis, maybe to see if that's going to work out, and moving away from the 0 hour structure. In terms of other things, you could implement shift planning tools. So look at some scheduling software to manage the shifts more efficiently. Make sure that your workers are receiving reasonable notice of their shifts, so that you're minimising the need to rely on last minute changes, so that there aren't any last minute changes that could result in costs for the company. And then also prepare for additional costs. If you are going to continue with individuals who may be working in this structure, then there may be increased tribunal claims incoming, or there may be compensation needed to be paid for cancelled shifts if you find that you can't move out of a 0-hour structure.
Thanks, Jackie. Moving on then to ending fire and rehire. So firstly, what is fire and rehire? This is the process that some employees use when they want to make contractual changes to employees' terms and conditions. So at the moment, if employees refuse those changes, there's an opportunity for the employer to dismiss the employees and then re-engage the same employees on the less favourable terms, and/or engage different employees on those less favourable terms. Now, whilst that is possible at the moment, it has already been quite heavily criticised, and it's not a route that is deemed favourable by the government. The Employment Rights Bill goes a step further and is going to make these types of situations where if proposed changes are made, employees don't agree and are then dismissed, that will become an automatically unfair dismissal straight away for if you're dismissed for refusing a contract variation. There won't be a qualifying period for that, and the exceptions to when that is possible will be extremely limited. So only when the company's in extreme financial distress and effectively would collapse if this didn't go ahead. Given that it will be an automatically unfair dismissal and there's no qualifying period, using these practices going forward will be extremely risky. It will open the door to unfair dismissal claims and financial compensation. So really there has to be a greater emphasis on reaching a reasonable position with the employees. Lots of employers do this anyway and will offer incentives to push changes through. But clearly with this additional emphasis on it, there's going to be more administrative burden around doing that and more time-consuming processes. And potentially it will give employees more scope to push back. If they feel more protected from a dismissal, then they may not agree to things that they previously would have because they know that they can't be dismissed. It's a tricky situation for employers because sometimes employers have really good reasons for needing to change terms and conditions in this way, harmonising terms or trying to avoid redundancies even by changing terms and conditions. So whilst you can understand where the government's coming from, trying to protect employees from being terminated and under risk of having lower terms, actually it feels to me like a bit of a blunt instrument in terms of that it could push some employers into more difficult situations where perhaps redundancies have to be considered as an alternative if you can't agree a change of terms and conditions and cost reductions still have to be made. It may be that employers need to think of different routes, and redundancies could be one of them. Anything else from you, Jackie, on the practical side of things?
Yeah, sure. So I think first of all, what you can be doing now before any of this comes up maybe is audit your employment contracts and ensure that you actually have clauses in there which would allow you some flexibility in order to change terms in the first place. And you would need a reasonable timescale in there, and make sure that your policies are up to date. If there are going to be any significant changes that you are looking to implement, then we really would suggest getting legal guidance from Nicky early, and that would maybe help reduce any further risk or legal problems further on. But when it actually comes to the processes, from a soft angle, engage early, communicate transparently with employees. You need to, again, equip your management team with the skills to be able to handle those consultations to begin with. They need to have the negotiation skills to be able to deal with their employees and explain everything properly. Ultimately, employees might not want the changes that you want to implement, or they might not be happy with the outcome of a process, but at least if they can understand the reasoning behind it, and they believe that the manner that the process has been carried out was fair, and that it's been communicated in a respectful way, and it aligns with the values of the business, then there is then an improved chance of being able to move forward with those changes that you want to implement with a more positive outcome for everyone. So yeah, again, banging that drum about training, but I do think that that's going to be key to this as well.
Thanks, Jackie. So there's a few more smaller updates from the Employment Rights Act Rights Bill that we'll touch on now. So firstly is protection from third-party harassment. So currently, employers aren't liable for harassment by third parties. So if you had a receptionist who was harassed by a customer who came into your business, currently, as an employer, you have no liability for that. The Employment Rights Bill changes that position and makes employers directly liable if they fail to take all reasonable steps to prevent this type of third-party harassment. So the first thing to say is employers aren't in control of this. That you can't control whether a third party harasses one of your employees, but what you can do is start to take steps to protect against that happening. And when we think about what all reasonable steps means, it certainly errs towards employers being proactive. So taking steps after the event simply won't be enough to show that you've taken reasonable steps to stop this. So it's taking action early. It's looking at employees who might be at particular risk. Yes, of course, having policies in place, but also creating an environment where employees feel able to raise concerns, and also training again. Jackie and I are on the same page with this, making sure that employees understand what their obligations are to each other, and also in terms of external parties.
Yeah. As Nicky's outlined, of course, the new legislation did become live in 2024. It is going to be, it isn't good enough to retrospectively say, oh, look what we're doing now. The onus is on the employer to take all reasonable steps to make sure that their employees are safe in the workplace. So start putting clear processes in place. Conduct a risk assessment of your workplace. Are employees going to be at risk from other colleagues? Are they coming into contact with the general public? Are there any suppliers or what third parties are they dealing with as well? Will that heighten the risk? All of those sorts of things. So update your policies, make sure that you have clear reporting procedures in place for employees to make a complaint on any harassment that they've experienced. And just to really outline that you do have a duty of care. You've always had a duty of care to look after and protect your employees from harassment in the workplace, not just sexual harassment, from any sort of harassment. But you really need to make it very, very clear what is acceptable and what is unacceptable in the workplace, and how to report such unacceptable behaviours. And that is just a basic key thing that is your obligation. But you need to think about training. I know, again, Nicky, you touched on this as well, but you need to think about training employees on harassment, and to be clear that you find it unacceptable, no matter what the situation is, and that there will be consequences if that policy is breached.
Thanks, Jackie. Quickly to touch on statutory sick pay, because there's going to be a change there as well. At the moment, there's 3 waiting days before statutory sick pay is payable. And then it is payable at a statutory set rate, which is currently £116.75 per week. In the Employment Rights Bill, the change it proposes is that statutory sick pay will be payable from day 1, and it will also take away the lower earnings threshold. So the lower earning threshold is £123 a week. So anybody who earns less than that isn't entitled to any statutory sick pay at the moment. Going forward, once this comes into force, they will be entitled to it at a percentage rate of their hourly, of their weekly pay. It will have a bigger impact on some industries, some employers than others, and clearly on employees who are perhaps lower paid. So it could have an increase in terms of costs in those situations, and possibly an impact on absenteeism if more employees decide to take sick leave that could be paid. For other businesses, the impact's going to be minimal because lots of employers pay company sick pay anyway for a couple of weeks, or certainly for the first few days on a discretionary basis. So in those situations, less of an impact going forward.
Yeah. And then in terms of practicality, I mean, for sure, in certain industries, again, it may be the norm to only pay statutory sick pay rather than having that buffer of company sick pay, such as in retail and hospitality. But for sure, policies will need to be updated. Make sure that you, again, I mentioned earlier in the session about having absence trackers, but this is really going to be key here as well, to make sure that you are providing your payroll with the right information, so that those persons who qualify for that SSP are going to now receive it. And that also, again, that you make provisions for a potential increase in costs, which for sure, again, in retail and hospitality, where it is more the norm to not pay company sick pay, that will inevitably end up in some level of higher cost. Thanks, Nicky.
Thanks. So the final update from the Employment Rights Bill is an update to terms and conditions of employment will be required. So as things currently stand, Section 1 of the Employment Rights Act 1996 sets out a whole host of provisions that have to be included in employees' terms and conditions. So you have to say what training is going to be available, you have to say what benefits are available, you have to say if there's a collective bargaining agreement in force. All of those things remain. The Employment Rights Bill adds an additional obligation to put something into the employment contract around it, adding a statement that the worker has the right to join a trade union. So most private sector employees at the moment, employees won't be members of trade unions. It'll be interesting to see whether having to have this statement in their employment contract, could that increase membership of trade unions? Could we see more employees joining trade unions? Remains to be seen whether that would happen in practice, but what will absolutely be needed in order to be legally compliant is an update to the employment contract to add this provision in. So once that comes into force, employment contracts will need to be looked at and updated on that basis.
Thanks, Nicky. And I think you've touched on most of my points anyway, but for now, there isn't anything to do immediately, but be aware that that clause to make the employee aware that they are entitled to be a member of a trade union will likely become an obligation. So be prepared that you will need to update your contracts as and when they come into force. Again, you've touched on this, Nicky, that in the private sector, it's not normally common. Obviously, there is the odd anomaly, but it's not normally common for employees to be typically members of a union. But if there is an uptick in membership, then it is likely that we will be seeing more union representation in things like grievance meetings and disciplinaries, performance reviews, and so on. So that basically means that your managers are really going to need that training on how to handle company processes in those circumstances. Thanks, Nicky.
Thanks, Jackie. So we've cantered through there the kind of main changes that are relevant for SMEs in the Employment Rights Bill. And now we're going to touch on two other changes. So in terms of the ones that were in the Employment Rights Bill, they're proposals, they're not in force yet. They will be coming in probably in 2026. The next two are changes that are happening this year in April. So we will look at both of those. Firstly, more of a practical change than a legal one, really, but it's the rise in the national living wage and also in the employers' national insurance contributions. So in terms of the rise of the national living raise of the national living wage, that's clearly going to have an impact on costs for employers who are employing employees at that lower earning level. But the increase in the employer's national insurance contributions is having an effect across the board. The threshold for paying the employer's NICs is coming down, and there's also a rate increase from 30.8% to 15%. So there are higher costs across the board for all businesses who employ people. In terms of implications beyond the increase in costs, to me, it raises the question of, is this going to be a barrier to employing people going forward if costs are squeezed? And will this make employers think of perhaps different ways that they could engage? You know, is it going to push people into more independent contract relationships rather than taking on employees and being exposed to those higher costs? Jackie, over to you.
Sorry, I had myself on mute there. So in terms of practical steps, of course, your payroll systems need to be ready for those changes. And you need to obviously be prepared that there are going to be an increase in employment costs. And we are actually looking with a lot of our clients at the moment to introduce salary sacrifice as a default for pension structure or pension contribution structure as a way to try and mitigate that 15% increase on the employer's NICs. Now, of course, just as I'm not going to turn this into a salary sacrifice training session, but of course, just so that everyone is aware, you can't force your employees to take salary sacrifice. So even though you introduce that as a default, so you are making that 15% NIC saving on the sum of money that's being sacrificed towards pension. If the employee doesn't want it and they want to opt out, then they still have the option to have their default relief at source pension, but you know, it's a salary sacrifice most of the time is a win-win for employee and employer. So it is something that maybe you want to think about now before the April changes come. Maybe have a look and see if that's something that would work for your business, because if you do have a high headcount, as an example, this increase to 15% is going to increase on your cost base quite significantly.
Thanks, Jackie.
Nicky.
And then the final update that's coming in April is an entitlement to neonatal leave and pay. So in broad terms, this entitles parents who have babies who then need neonatal care to up to 12 weeks of additional leave. So that's 12 weeks leave on top of any other leave that they might be taking. So on top of maternity leave or shared parental leave. The way that this leave will work is that the right to take the leave is going to be a day one right, and there will be statutory pay available for those who have 26 weeks service. The way it will be offered to employees is that it will be tagged on at the end of any other leave. So if a pregnant woman goes off, they have a premature baby, the maternity leave will kick in straight away. But if, say, that baby was born 3 months early, they spend the full 12 weeks in neonatal care, then they will have 12 weeks of neonatal care leave that they can tag on at the end of their maternity leave period. Begs the question of how this might be used in practice, because the last 12 weeks of normal maternity leave are completely unpaid. So you may get a situation where people are bringing their maternity leave to an end early, taking the neonatal leave and receiving some statutory pay during that period as well. it only entitles the employees to up to 12 weeks, depending on how much time their child has actually spent in the neonatal care unit. So if they have only spent 3 or 4 weeks in there, they'd only be entitled to tag on that additional 3 or 4 weeks. Jackie?
Yeah. Thanks for that, Nikki. I mean, I personally think it's a great move. You know, internally at Goodwille, we've had situations where this leave has been needed, and of course, it's a company decision as to what you do in that circumstance, which is an awful position for a new parent to be in. So practically update your leave policies. Think about whether you are just going to pay the statutory rate or whether you will give an enhanced rate as well as a more of a bespoke offering. Prepare your payroll systems for those changes, inform and train managers again on changes and how they can best communicate that to their employees. But also, above that, think about maybe if there's anything extra that you, in line with the neonatal policy that you might be implementing, what sort of support could you maybe offer that's over and above the rate of pay and leave that might be needed? So maybe are there any counselling services that you could maybe offer as a package? So there's all sorts of things that you could be doing with this sort of leave in mind. Thanks, Nikki.
Super. So that brings us to the end of the updates for 2025, and I'm very conscious of time, but I thought it was useful to kind of canter through the key updates that happened in 2024 as well, just to bring us completely up to date. So we've touched on some of them already. There's been updates to flexible working to make it a day one right, to make it possible for employees to make 2 requests per year, and there's a new ACAS code to follow there. Carers leave came in last April, and that gives all employees the right to 5 days unpaid leave if they need them for caregiving responsibilities. The right to paternity leave was also made more flexible because it can now be taken in blocks of 1 week and 1 week rather than previously the 2 weeks had to be taken together. It can also be used within the first year of the child's life rather than previously it was within the first 56 days. We've touched already on the extended redundancy protections, which mean that it's not just during maternity leave that women have the right to the first refusal on in terms of redundancy alternative roles, but this extends to other types of leave, and it also extends after the maternity leaves come to an end because it's for 18 months after the birth or the adoption of the child. There have been some helpful, I would say, changes to holiday pay calculations. So at least one of the changes we're mentioning is hopefully a positive for businesses because it makes it more practical to calculate holiday pay for irregular hours workers or 0 hours workers or seasonal workers, etc. And then in autumn, as we've touched on already, there was a change in the laws around the duty to prevent sexual harassment. So that ties in with that employment rights bill proposal that around third-party harassment. We've already seen this in relation to preventing sexual harassment and a further duty on employers to take reasonable steps to prevent that. So a quick canter through those. If anybody does have any questions on those, please feel free to ask. But we will just finish up with Jackie taking us through our top tips for staying compliant.
I did say I was going to sound like a broken record, didn't I? But, at least I'm consistent. So yeah, in terms of tips, again, just make sure that you are on top of reviewing your contracts and policies. Make sure they're up to date, that they are reflecting the correct legislation and best practice. Make sure you're training your managers, and they are the people on the ground. They are the ones dealing with your employees on a day-to-day basis. I can't tell you the amount of complaints that we get routed via the HR team at Goodwille, and 9 times out of 10, it's a relationship issue with the manager, or someone doesn't know how to manage their team or have that difficult conversation. So it really is key to make sure that you have the best people and give them the best tools to be able to deal with their team. And then also monitor legislation developments. Again, you know, I'm sure that Ignition keep you all really well informed of what's on the horizon, but it's really important to take note and to plan, because there are an awful lot of changes, I'd say, that are coming in the next 18 months, and it's really important to be prepared. I think that's all from me.
Yeah, so I know we're kind of up against it, but we have got 4 minutes left. So if anybody has any burning questions that they'd like to ask now, please do, and we'd be happy to answer them. Equally, if anybody has any follow-up questions or thoughts afterwards, then do please feel free to drop us an email and ask away.
Thanks, Nicky and Jackie. The only question I had, which is one that I popped in the chat earlier for sort of other people's views as well, is really which of these changes do you think is going to require the most careful handling, and which do you think is going to sort of cause the most changes in terms of companies' procedures?
I think it's going to be the day one rights on unfair dismissal. As soon as myself and my team heard that, it was just alarm bells ringing. So I think, yeah, it's kind of sent shockwaves throughout the community, I think. But Nicky, what do you think?
Yeah, agreed. That's absolutely my top change as well. It will be interesting to see what transpires in terms of this lighter touch process that's required during the first 9 months, because in reality, if somebody's not the right fit or not performing in your team, 9 months should be enough time for that to be flagged up and for that to be dealt with, and perhaps if we kind of turn it around and try and find a silver lining, it's going to help businesses be more proactive in making those decisions sooner. But as we all know, things sometimes do go unnoticed, and once we get past that initial period, you know, it is going to create more risk, and also around the quirk around redundancy dismissals within that first initial period, where actually they are still subject to the full unfair dismissal principles from day one. I think that's also, you know, really onerous on businesses, frankly. So it is going to be a big change, and definitely one that's going to take a little bit of time to work through when it does come into force.
Yeah, thank you both. Interesting times ahead.
I think an unintended consequence might be companies wanting to start off a relationship with a new employee on a contractor basis rather than going straight to FTE.
I think that is likely, Max. Obviously you've got different considerations around that on, you know, is the person truly a contractor versus are they, you know, would they deem to be an employee based on the kind of actual facts of the situation. But certainly it is a way to mitigate against the kind of day one unfair dismissal risk, is to kind of have a, you know, try it first on a contractor basis before you then commit to employment.
You've got to get the buy-in from the individual as well, though, don't you? Because some people want to be employed, they don't want to be a contractor. So it's maybe a bit more of a sell, I'd say.
Yeah, I just think in such a tough jobs market, it's I feel like it's going to have unintended consequences, that bill.
Can I just ask a question? Where do fixed term contracts come into play here then? Because obviously you bring a contractor in, you've got the whole IR35 issue. What about fixed term contracts instead?
Yeah, so with any fixed term contract, and it's the same now, you do still need to have your reason for your dismissal at the end of it. It might be if the fixed term contract goes on for longer than, so part of this initial period, and what the government said about that is, as long as you serve notice within that initial period, if the notice expires up to 3 months after that, you'll still be covered by the lighter touch approach, meaning that you could have somebody on a fixed term contract for a year, because provided you then serve the notice within the first 9 months, you're then in the lighter touch process still within that year. But you would still need to give your reason, you would still need to follow the lighter touch process for dismissing that fixed term employee.
Thank you for that.
Thanks everyone. I'm afraid I'm going to have to leave because I'm being knocked out of this room, but thanks so much for attending everyone, and thanks so much Nikki and Ignition.
Thanks Jackie.
Thank
Thank you. Bye.